Learned counsel for the respondent submitted repeatedly that the above interpretation would be inconsistent with the intention of the testator as clearly expressed in the will. Stop. He submitted that the first and the foremost rule of interpreting the will is to ascertain the intention of the testator and to give effect to it. Stop. The learned counsel submitted that according to the will, the doctor's house was to devolve upon the legal heirs of the testator only on the death and not to any earlier point of time. Stop. He emphasized the words and declared that after her death, the property will go to the legal heirs of the testator occurring in clause of the will. Stop. It is true that is what the testator said, but then the said will has to be understood and construed in the light of the statutory rules governing the will. The provisions of the Indian Succession Act 1925. Stop. Section 119 of this act, which applies to the will in quest by its own force, says to repeat that where a property is bequeathed to A for life and after his death to B, the legacy to B becomes vested in interest in B on the death of the testator. Stop. As pointed out earlier, the bequest in the will squarely falls within the four corners of section 119 and in particular of illustration thereto. Stop. It may be remembered that illustrations to the section are parts of the section and help to elucidate the principle of the section. Stop. The respondent then contended that the use of the plural heres and not the singular here in clause is indicative of the intention of the testator that he was referring to his legal heirs as may be in existence on the death. Stop. In our opinion, this argument is plainly unacceptable. Stop. In the year 1942, he could not have foreseen the enactment of Hindu Succession Act 1956 or that in future his daughters would also become his legal heirs. Stop. The next question is what happened in the year 1955 when there was a settlement between them and the first defendant and what is its effect? Question mark. As mentioned herein above, soon after the death in the year 1953, suits arose between the first defendant. Stop. As many as suits were filed by one against the other. Stop. The first defendant had put forward a rival will said to have been executed in the year 1950, where under the doctor's house was given to the first defendant. Stop. Para. By allowing adjournment motion on Punjab problem, which is a national problem of serious concern, you have accorded it national importance. Stop. We are grateful to you for this. Stop. But I expected that the honorable members of opposition would also be equally serious to this motion and would offer some sort of suggestions today which would go a long way in solving this grave problem of national concern. Stop. I was disappointed to hear the speeches of the mover of this motion and other members of opposition who spoke after him. Stop.